How to gain access to a bank account after someone has died. Hi, I'm Darren Findling of the Probate Pro. And when somebody has died, one of the most important things that people want to get access to is a bank account. They need it often for things such as payment of funeral and burial, maybe the next lease payment or mortgage payment, and they can't get access, and it causes tremendous frustration. The banks aren't of much help, because if you go to the bank, they're often going to tell you that they can't give you any information about the account, let alone the value or whether there's a joint owner or a named beneficiary. In fact, many banks will freeze or place a hold on the bank account the moment they're identified or told that somebody has died. So what do? You got a few options. The easiest and best option is if the bank account is quite small, under $27,000. You can use a form called an affidavit of decedent, successor, and interest. It is a non-probate process. It is a single-page form that requires a signature and a notarization. It can be used for bank accounts that are smaller, under $27,000. After 28 days have expired from the date of death, it can be used to gain access, and then the money is distributed from the bank account to the party that has the right to receive it, the next of kin. That is the easiest process to get money out of a bank account when somebody has died. Another process is the petition in order for assignment. This is a probate process, but it is a short form probate process, which means that rather than getting a letter of authority and going through a full probate administration, it is a petition that is filed with the probate court. It is usually done in one day, and there's a court order that then assigns the value of that account to the named next of kin, or the beneficiaries or heirs, depending on the circumstances, the rightful people to receive that bank account. It's another great, effective way to get money out of a bank account that is smaller in nature. But what about if it's larger, or if there are other assets that need to be administered? Then you're only left with a full probate administration, meaning the filing of an application or petition for probate, the appointment of a personal representative. If the amount is still small, you can close it through a summary proceeding, but generally this process is more involved and more costly. As I mentioned earlier, the affidavit process has no filing fee. It's a non-probate process. The other two do have filing fees. If you've got questions about probate-related issues, visit us at theprobatepro.com or call us at 833-PROBATE.